Good morning, everyone.
Good morning.
Good morning to you all. Good morning to you all. Well, it is my very greatest pleasure to be asked to chair this first panel of the first inaugural Africa Arbitration Day. I'm very happy to be associated with both our hosts today as a honorary fellow of both BIICL and a professor of international commercial law at Queen Mary University. It's very often said by a chairman that we have a distinguished set of panelists, but today we have a star-spangled group of panelists. And let me briefly introduce them. Ambassador Dr. Namira Nabil Negm is the legal counsel and director of Department of Legal Affairs of the African Union. She has a PhD in public international law from London and an LLM from King's College there. She is a seasoned diplomat, having served as ambassador of Egypt to Rwanda. She's on the roster of legal experts of the League of Arab States. She has been legal advisor and counter-terrorism expert of the Egyptian mission to the United Nations. She's also served as the legal and political officer in the Embassy of Egypt to the Netherlands. And she's also been head of the anti-corruption unit at the Ministry of Foreign Affairs of Egypt. She's the author of a number of publications in the field of international law, including her book on transfer of nuclear technology under international law, case study of Iraq, Iran, and Israel. Next, let me introduce Tafadzwa Pasipanodya. I hope I've got that right, Taffy. I've been practicing it all day. Taffy is a partner in Foley Hoag LLP's International Litigation and Arbitration Department from Washington, and she is co-chair of its Africa practice. She has served as counsel to sovereign states from all over the world before international courts and arbitral tribunals in state-to-state and investor-state disputes concerning natural resources, mining, human rights, the environment, infrastructure, the law of the sea, territorial boundaries, and cultural heritage. That doesn't leave much else, Taffy. She also represents foreign states in US federal court proceedings. She's a member of the Executive Council of the American Society of International Law and Vice President of the African Society of International Law. Thirdly, to make up the trio, we have Professor Makane Bang, Professor of International Law at the Faculty of Law of the University of Geneva and Director of its Department of International Law and International Organization. He's also an affiliate professor at Sciences Po in Paris of the School of Law there, and he is the president of the African Society of International Law. Makane has acted and acts as expert for the African Union and many other international institutions. And he is currently involved in the negotiations of several international investment agreements in Africa. And he also acts as counsel in disputes before international courts and tribunals, in particular before the International Court of Justice and in investment cases, as well as advising governments and acting as an arbitrator in investment cases. And as one would expect, he's the author of a number of publications in the field of international law. So there we are. Now, I'm your chair. I've been asked to keep the panelists to their allotted 10 minutes. I will be ruthless in that task. And when I hit with my pen on the glass of water that I've got in front of me, hope you hear that. Nice 18th century rummer, because I collect glass. You will have 1 minute left. So now, our panelists are going to speak in the order of Ambassador Negm, and then Pasipanodya, and then Professor Bang. Ambassador Negm is going to speak from the point of view of international and intergovernmental institutions. Tafi will speak from the point of view of a practitioner with daily contact with the practical problems of inclusiveness as it affects international arbitration. And Professor Bang will speak of strategies for finding solutions to current challenges to inclusiveness. So let's start with Ambassador Namira. Over to you.
Thank you very much, and good morning, everybody. It's my pleasure to be with you today, and I will try to honor my time, maybe less even than the 10 minutes, I hope so. As Sir Bernard rightly indicated, I'm going to focus on the role of international organizations, specifically the African Union at this stage, because this is where I'm working right now, on our role in trying to be part of the inclusive approach to arbitration. We have actually, since the establishment of the OAU, which is our predecessor of the African Union in 1963, we worked a lot with the African states in order to harmonize their rules and have regional approaches to African arbitration and other legal issues. We have been, within the AU, we always try to address the disputes first through diplomatic channels, and we have quite an important role in trying to sort out some of the issues through these diplomatic channels. Also, in order to do that, we are trying to promote so much the expertise within our continent, which is, we are trying to play actually a pivotal role in making sure that our unity will also include the support of our experts. When it comes to the, I will speak a bit on a few of the elements regarding the inclusivity attempts from the African Union. One of them, I will start by the attempt of promoting African lawyers in dispute settlements, because as rightly indicated, but by so many, that we don't have enough African lawyers hired for arbitration in the international sphere. That doesn't mean we don't have enough African lawyers who are capable of handling these cases. We have more than enough, and my experience showed that. In our attempt in the Office of the Legal Counsel in the African Union, we had brought in both very, very important cases that we tackled in the last couple of years, only African lawyers. One is the ICJ advisory opinion on the legal consequences of the separation of the Chagos archipelago from Mauritius. We had the two lawyers, including one of them with us in the panel, Professor Makane from Senegal, and we had another lawyer from Egypt. And when we submitted an ICC amicus curiae on behalf of the AU in the Jordan's appeal before the ICC, also we had African lawyers from Sierra Leone and South Africa. Moving on to part of our role in shaping some of the policies that are important to ensure some of our inclusivity, to be included actually as Africans in the international arena. We try to arrange the house first, and happily I can bring to your attention, if you don't know, some of you probably may know, some others may not, that we adopted the biggest free trade agreement in March 2018, the African Continental Free Trade Agreement, and that was a milestone for us. The CFTA agreement has protocols in trade in goods, services, and it has one on the rules and procedures of which is very important. It will include arbitration. Now, just because of it was the fastest agreement somehow in our history to enter into force. It was only 1 year since the adoption. It entered into force in May 2019, and we have 55 African countries signed it and 28 ratified it. The CFTA offers a lot of significant developments, not only in trade, but also in investment, because there will be a protocol in investment, and it will help a lot to bring the continent together. When it comes to the dispute settlement and legal issues, of course, this will be a vast opportunity for lawyers within the continent to work with governments on it. The other issue is when it comes to the BITs, we are trying to work with internally and with our member states to review the bilateral investment treaties of the African states, because some of them, as we have seen, they are not balanced so much when it comes to the African interests. And it was very important to try to play a role to make sure that the BITs are in more balanced way drafted. And we are discussing now how can we work it out. The African Union supports a study and review of the BITs to support our member states in this ongoing discussion on the international level. We have also contributed to the amendment of the exit rules, and we have been trying to support our states as much as possible. And we submitted some of our observations because we want to make sure that there is some diversity in the regulations of exit, because this is very important also to take our point of view on board. The other issue is the reform at the level of the Decentralization Working Group 3, which has many proposals now. Of course, everything is a bit lagging behind because of the COVID, but this is an international issue for all of us. But we are trying as much as we can within the within the UNCITRAL working group to come up with an African position in the negotiations regarding the investor-state dispute settlement, and to tackle all the new proposals coming up in order to see what is favorable somehow to Africa. The last thing I want to touch upon is our capacity building initiatives to support African Union member states. We are trying as much as we can in my office to arrange capacity building initiatives. We adopt a lot of approaches. Even as we speak now online, we have one, but it's not on arbitration. But in the last few years, we held so many trainings in different locations in the continent. We started in Dakar in December 2018, then in Cairo in 2019, in collaboration with the International Commercial Arbitration Center of Cairo and in Dar es Salaam in December 2019. All of these trainings included our member states' representatives that we wanted them to know more about the CFTA, the dispute settlement mechanisms within the continent and internationally, in order to be able to support their governments themselves when they are faced with arbitration. I know there are a lot of things that we still need to accomplish, but these are a few attempts from our side to ensure that Africa is there. Our capacity also is there to be part of the inclusivity efforts towards the accomplished goals to support our member states within the organization and within other organizations, including arbitration. I thank you. I honored my 10 minutes.
Absolutely, on the spot. Thank you very much indeed, Ambassador Namira. Now I'm going to call on Taffy to speak. I can see that it's dark outside there, and that reminds me that Taffy is addressing us from Washington and has got up very early this morning. So thank you very much indeed. Over to you, Taffy.
Thank you very much, Sir Bernard, and thank you very much to BIICL and all the organizers of this conference. It's wonderful that you're shining a torch on Africa and international arbitration in Africa through this inaugural Africa Arbitration Day. And I'm particularly delighted to be participating with panelists who I admire so much. Now, this important issue of inclusiveness in arbitration, or arbitrators in particular, really looks different depending on where you're standing. So I just wanted to say my perspective is that of an African lawyer based in Washington, DC, who represents states in international arbitration through a US law firm. Following the killings of George Floyd, Breonna Taylor, and several other African Americans through law enforcement, there's currently an acute awareness of racial inequality and inequity in the US, and it's spreading globally, this awareness. Many people here believe that there is an unprecedented collective understanding of the nature and extent of systemic racism and discrimination. And there's also a groundswell of support and efforts to address this racism and the lack of racial inclusion and lack of representation wherever they present themselves. And I, like many others, believe that international arbitration should seize this moment in time to recognize its exclusion of African arbitrators and people of African descent as arbitrators, and to try and ensure that international arbitration can more aptly wear this mantle of international. It's of course no secret to anyone in this virtual room that there's poor representation of African arbitrators, particularly in investor-state arbitration, which is the kind of arbitration I'd like to focus on. Most of you who appear as counsel in investor-state arbitration disputes can probably count on one hand the number of times you've appeared before a Black arbitrator. And most of you who are arbitrators can probably count on one hand the number of times you have appeared on a panel with Black arbitrators in investor-state arbitration, if at all. And the ICSID caseload statistics that were released last month reflect this. They note that since 1966 until now, African arbitrators have participated in 2%, just 2% of all the cases that ICSID has had on its plate. A 2018 SOAS Arbitration in Africa survey also confirms what we all know, that people of African descent are rarely included in international arbitrations for investor-state tribunals. And it would be interesting to do a poll of you here to understand the varying views on the extent to which this is a problem. And those of you who think it's a problem probably have varying views on why it's a problem. Now, I should state that having served as counsel on in numerous cases with all white arbitration panels, I personally have no doubt that they can and have meted justice fairly and honorably, even in cases that are concerning Africa. So this is not my own concern. My primary concern with the exclusion of arbitrators of African descent from investment arbitration are twofold. First, that I know that numerous extraordinarily talented arbitrators of African descent feel that they are not picked to be arbitrators on the basis of their race. And to the extent that it is true that qualified people are excluded on the basis of their race, I think this is problematic and should be recognized and addressed by the international arbitration community. The second reason why I think the exclusion of people of African descent in investment arbitration is problematic is because these arbitrators are making international law. They're deciding when an exercise of regulatory authority is unfair and inequitable. They're deciding when an investment is worthy of protection. And they're deciding critical questions of compensation and deciding where a state is liable, the extent of the compensation, sometimes using approaches that depart quite extensively from customary international law. Now, the call that Africans participate as full actors in the making of international law is, of course, dates back to Bandung in 1955, when African states and Asian states met to discuss and protest their exclusion as actors within international law. Given the immense lawmaking power wielded by arbitrators and investment arbitrators, I think it's time for us who are practicing international arbitration today to ensure that Africans, like people of all over the world, are involved in the establishment of new norms of international law through international arbitration. I recently watched a very interesting webinar on racial diversity, in which a few of the most leading practitioners of our field were discussing this issue. It drew my attention that one speaker, who's the head of a leading arbitration institution, administration institution, mentioned 3 times that the key problem was that African states don't appoint African arbitrators in investment arbitrations. And over, the speaker expressed frustration with African states because they didn't pick African arbitrators. And so since this is a common comment at events discussing this issue, I wanted to address it very briefly from the perspective of someone who is often advising states in their selection of appointing an arbitrator. In my personal view, an African state's decision not to appoint an African arbitrator in an investment arbitration dispute is not explained by some incomprehensible self-loathing. I also don't think it's primarily because African states sometimes seek counsel in these investment disputes from international law firms based in Europe and America. I say this because often in cases in which states are represented by law firms based in Africa, the states will nevertheless pick a non-African arbitrator as their party-appointed arbitrator. In my view, African states, when they make this decision, are facing decisions that every state is facing, and they are realizing that the appointment of an arbitrator is one of the most consequential decisions they will make throughout the whole proceeding, second probably only to the selection of counsel. And the nature of investment arbitration currently is such that it is critically important that you pick an arbitrator who's not only smart and capable of rendering a fair decision on the basis of the law and facts in front of them, but also one who might be able to convince the president of the tribunal to agree with them and not the other arbitrator. So as counsel, one has at the forefront the persuasive capacity of the arbitrator one might recommend for one's client, knowing full well that the president and the way that they decide will likely sway the outcome of the decision. And there is, of course, no appeal in this system. As long as the stakes are high, and all states, including African states, will need to be cautious and highly strategic in appointment of arbitrators, picking someone whom they think has the stature and the ability to persuade other non-African arbitrators to decide with them is going to be of primary importance. And there'll be discussion on investor-state dispute settlement reform in later panels in this conference, but I think it's worth realizing that having some sort of appellate system might very well help with the inclusion of arbitrators, because states and investors, might I add, may not feel the same pressure and need for caution in their appointment of an arbitrator if they know that there's an appellate review system that they can resort to if a decision rendered against them seems wrong. My final point then is that although states obviously have an appointed role to play in making investment arbitrations more inclusive, given the dynamics that they are facing in the arbitrator selection decision, arbitral institutions and other arbitrators could do more to foster inclusion. The arbitral appointments made by administrating institutions are typically fewer than those made by the parties, but they are sometimes, for some institutions, up to almost 50% of the appointments made. So these institutions could and should appoint more arbitrators who are African. And similarly, party-appointed arbitrators on a panel could do more to ensure that the third arbitrator that they pick as president is an African arbitrator. Often it is either them or the administrating institution that picks the president. So even just a slight improvement by either could make a significant difference in increasing inclusion. There's a concern often amongst institutions and arbitrators that they simply don't know qualified African arbitrators whom they might select. And this is a concern that has begun to be addressed by several institutions and organizations. So I just want to highlight this because it is a valid concern that people raise. Many of you have heard of Arbitrator Intelligence. This is an organization that reports on the track record of arbitrators. And this is very helpful for states trying to select arbitrators when they have the track record and have a database of information on arbitrators. And so I encourage people to participate in it and to share their experiences with African arbitrators within this forum so that we can continue to have a deeper understanding of the way that African arbitrators make decisions. More recently, there was an initiative that was begun by Dr. Simpson and Dr. Tevenen a few months ago, which tries to list arbitration practitioners of African descent with a US nexus. I want to get it right that it's African arbitrators with a US nexus. And that list has a description of over 120 people that are involved in arbitration. And I was really impressed to hear that the Secretary General of one of the major institutions shared that with her staff and asked them to consider this list when they're making appointments. So this kind of sharing of knowledges and experiences and positive experiences that you've had with African arbitrators should be shared and can go a long way. And finally, very briefly, given the current understanding across the world that systemic racism and unconscious bias is more prevalent than what we might have believed, I think it's worth institutions and arbitrators being potentially aware that unconscious bias is at play in the decisions that they are making and that arbitrators are making about arbitrators. And so unconscious bias training, implicit bias training could be something that will assist the institutions and the arbitrators. And this is something where we have so many experts working on this in right now. I highlight the work of Alliance, working with arbitral institutions on bias training, and think that this is a small effort that could be taken to, again, make sure that decisions are not being made on the basis of implicit bias. So these are just some initial ideas. Thank you. These are just initial ideas, and I look forward to hearing the views of you and others on this efforts that we might adopt to ensure that international arbitration becomes more inclusive and truly becomes the international practice that we believe it should be. Thank you.
Thank you very much, Taffy. And now Professor Bank.
Thank you very much, Sir Bernard, for the introduction. Good morning and good afternoon to all. I would like to thank very much the organizers for the invitation. It is really a great pleasure to share this panel with Ambassador Namira and Taffy. So in the 10 minutes that I have been given, I would like to focus on the strategies that have been developed in recent and current investment negotiations in Africa in order to ensure and foster more inclusiveness of African arbitrators, in particular in investment arbitration. And when we look at those strategies, I think we can emphasize three main strategies. The first one, I call it delocalization of inclusiveness. The second one, I call it decentralization of inclusiveness. And the third one, I call it Africanization of inclusiveness. So let me start first with the delocalization of inclusiveness. This strategy, the objective of this strategy is basically to encourage universal arbitration institutions to establish centers in Africa. So for instance, the establishment of a NICSID center in Africa, the establishment of a PCA center in Africa. And of course, when I talk about Africa, I talk about the institutional cradle, which is Addis Ababa. Having those universal arbitration institutions being close to the African Union in Addis Ababa, this is the strategy, the meaning behind the delocalization. And the main benefit of delocalization can be described as the psychological effect it would create. Psychological effect at two levels. If we have those universal arbitration institutions in Africa, this would push more the parties, states, but also investors to think more about appointing African arbitrators. We also believe that from a psychological level, these centers being closer to Africa would push also those arbitration institutions to be more familiar, more acquainted with the arbitration community in Africa. The second layer, the second level of psychological effect of the delocalization is that I believe that it would contribute in strengthening a culture of investment arbitration in Africa. If African lawyers feel closer to those institutions because they are in Africa, this might prompt the development of a greater culture of investment arbitration in Africa. So more people specializing in investment arbitration and then allowing more Africans to be appointed in investment proceedings. So this is one of the major approach that is on the table. This has been pushed forward mostly by the Pan-African Investment Code, which is an investment model at the level of the African Union. Second strategy that we find in practice is what we call the decentralization of inclusiveness. There is one constant observation, one constant reality when it comes to appointment of arbitrators in disputes in which African states are involved. That constant observation is that most of the time, African countries appoint arbitrators because they are advised by the law firms that they are working with to appoint this or this as an arbitrator, or sometimes some of those arbitrators are just appointed because of some obscure networks. This is a constant observation we have been making on the continent. So the idea of decentralization would consist in giving the authority to the African Union or to regional economic communities to actually establish list of competent African arbitrators. And then when African countries have disputes against them, investment disputes against them, the idea would be for those countries to actually appoint their arbitrators on the basis of those lists that have been established on an objective manner by the African Union or regional economic communities. And there I would say that the main benefit of this strategy of decentralization would be what I call the prescriptive effect. If you have such lists, if you give the authority to the African Union or to regional economic communities to be in charge of list of African arbitrators, then this would oblige de facto, at least, African states now to appoint African arbitrators when they have disputes. This might even encourage also foreign investors to go and look into those lists of African investors when they have disputes. So this is one of the strategy that is actually being very much discussed right now in the context of the negotiations of the future investment protocol to the African Continental Free Trade Agreement. Last but not least, there is a third strategy that we find in current investment negotiations in Africa, is what we can call the Africanization of inclusiveness. I don't want, of course, to preempt the discussion of the panel on seat of arbitration, but there are more and more voices in investment negotiations in Africa that are calling for investment disputes that to be settled or to be solved by African dispute resolution centers, by African arbitration centers. So the idea of the Africanization is actually to contemplate the idea of having disputes involving African countries and arising, of course, from African investment instruments to be solved by African dispute resolution centers. And there, the main benefit would be what I call the grassroots effect. If you have African arbitration institutions, African dispute resolution centers in charge of settling disputes, investment disputes, then of course you may have more African arbitrators being appointed, because those African arbitration centers are more familiar, more acquainted with the African arbitration community, and this can have this grassroots effect and bring more inclusiveness when it comes to the appointment of African arbitrators. So these are the three main strategies, and I would be very happy to discuss them further. But since I have 2 minutes remaining, I would like just to make a short conclusion, Monsieur le Président, on what I call the needs of inclusiveness. I think there are three main needs. The first need, inclusiveness needs capacity building. If we want African arbitrators to be more considered, to have more chance to be appointed, we need to strengthen capacity building in the field of arbitration on the continent. And we can come back to that in the discussion, but for instance, an initiative like the African Arbitration Academy is contributing to such need. Second need, inclusiveness needs push from the arbitration institutions. I'm not saying that arbitration institutions are not doing anything. ICSID is trying its best, ICC. I know that more and more arbitration institutions are doing their best, but I think we need more. We need those arbitration institutions to be more proactive in ensuring, in defending, in promoting inclusiveness. And then last but not least, I think that if we want to foster inclusiveness, we need now to think more and more about inclusiveness as part of litigation strategy. You know, in many examples, in many instances, you have states that do not accept awards, or you have states that decide to go for annulment against some investment awards, because actually, after the award is rendered, they are wondering, well, why was there not any African actually in this case? Why was there not any African? Why should I consider this award as being legitimate? And so I think it's very important for all of us that are involved in these activities of investment arbitration to realize that inclusiveness is actually a positive element of the litigation strategy, and this can contribute to better days for investment arbitration. So thank you very much, and I'm looking forward to the discussion.
Thank you to all the panelists for those really intriguing addresses. I would now invite anyone who has a question to put to any of our panelists, or all of them, to share them with us in the chat box. And while that is happening, let me ask a question, for instance, of Professor Mbengue, who spoke last. Amongst the strategies which you have outlined, which of your strategies do you think would be better or best to integrate and develop in the future investment protocol to the African Continental Free Trade Area?
Thank you very much, Monsieur le Président. Well, of course, I believe that the three strategies has some merits, but we see that there is fragmentation. We see that there are different directions. And of course, the objective with the future investment protocol would be to come with a more coherent approach to inclusiveness. So if you ask me my personal preference, I would say that I'm very much in favor of delocalization. We have recently published a special issue of the ICSID review, edited it with Makane and Paul-Jean Lecanu on the ICSID system and Africa. I think it was the first time ever that an entire issue of the ICSID review was dedicated to Africa. And one of the ideas I've been defending in that special issue is the need to have an ICSID center in Africa. And the reason for that is that I believe that we should actually build upon the universal acquis. I think that, you know, fostering inclusiveness doesn't need also to reinvent the wheel. We have some great universal arbitration institutions that have the experience. And I believe that having those institutions in Africa can actually be an added value, and it could foster a culture of more inclusiveness of African arbitrators within the realms of those institutions. So for me, I'm very open to this idea of Africa building upon the existing institutions, Africa building upon the universal institutions, and go for the delocalized approach. So that would be my preference, of course.
Thank you very much indeed. Now, there is a question from Solomon Ebere, who is a London-based lawyer, for Tafi in particular.
I think he can ask this question himself, because
yes.
we just promoted those people who asked their questions. So if you could turn on your video and audio, or just audio, Solomon, and ask your questions, that would be great.
Thank you very much. Thank you, Sir Bernard, and thank you for the panelists for their amazing presentations. I had a question for Tafadzwa. I'm sorry if I'm butchering your first name. It happens to me a lot of the time. I was wondering whether in your practice as a Washington, D.C. based lawyer, and especially representing sovereign states, you see a lot of African states now pushing for some sort, well, for at least a few counsel being either Black or African. That's my question. Thank you.
Thank you very much, Solomon. And you said my name perfectly, Tafadzwa. It's phonetic, my first name. The last name is a little bit more difficult, but Sir Bernard said it perfectly too. So thank you for this question. It's an important one, and I think that, you know, it's hard to generalize always with all African states, but with the states that we work with, I feel that there is increasingly a request that counsel be African, and that decisions are made when states are picking between two firms. I know for sure that they have considered the extent to which counsel are African, and even when there's a group of people who are representing them, or a team of lawyers, ensured that the African lawyers are actually one of the people speaking or presenting. I think many attorney generals in Africa are now making this this appeal, which hasn't always been the case, and I think is really should be commended and supported and done by more. Thank you for your question.
Thank you very much, Tafi. Would any of the other panelists want to join in on the answer of that? Yes, Makane.
Yes, thank you, Sir Bernard. I agree with Tafi. If you look the evolution, we can see that today there is more and more awareness from African countries to try to have African counsels in their team, or at least to have one of them among some other counsels in their teams. But there I would like to praise, of course, also the work of the legal office of the African Union, and in particular the work of Ambassador Namira, because what Ambassador Namira didn't point out is that recently, I don't know if it was a year or 2 years ago, there has been actually a note that has been circulated by the African Union Legal Office, you know, encouraging African states to appoint more and more Africans as counsels or as arbitrators when they are involved in interstate disputes or commercial disputes or investor-state disputes. And this shows also how it is important for institutions to play a role. This brings me again to my message that universal institutions, regional institutions, they have a huge responsibility there. They can change the mindset of the African countries. But Solomon, to jump back on what you have said, I think it's very important to have African councils, but those African councils, they also need to think about appointing, you know, African arbitrators and so on. No, it's not necessarily that because you have African council that they would necessarily appoint some African arbitrators, and we've been seeing examples of that. So I think we need also those African councils to be aware also of that need for inclusiveness.
Right, thank you. I'm now going to ask BIICL Adolu to ask his question. BIICL?
Yes, thank you very much. Bankole Adolu is my name, and I'm a doctoral researcher in Robert Gordon University. My interest is in jurisprudence of justice delivery through arbitration. So my interest is actually about the justice part of arbitration. Now my question is this: has there been any research at all that shows that the current position as it is now, that exclude, in quotes now, African arbitrators from the field, as is resulting to injustice to arbitrating parties? That's my question. And if there is any, I'm just very curious to know if there is any at all. Then if there is none, then don't you think that the whole issue of rebalancing, having more African arbitrators in the field is focusing more on arbitrator practitioners than the arbitrating parties, who should be the main goal and focus of arbitration? Thank you.
All right, who would like to answer that? Yes, Makane.
Thank you, Sir Bernard, and thank you very much, BIICL, for this excellent question. You know, the backlash, what we call the backlash against investment arbitration in many African states is actually the result of this feeling of injustice linked to the fact that, oh, it's only a club that is deciding the investment disputes. I mean, just take one country, I can say the name because it's official, it's public, South Africa. South Africa is very clear on the fact that one of the reasons why they do not subscribe anymore to the investment arbitration system is because they believe that those disputes are decided by people who are not familiar or who are not sensitive to the developmental objectives and concerns of African countries. And when we were negotiating the Pan-African Investment Code, some of the countries that were very much against it were using a lot in the room this narrative of, you know, there is not enough inclusiveness of African countries. And this is why the Pan-African Investment Code actually is opting for delocalization and Africanization. If you look at the relevant provision, you will see that what is recommended is either having some universal institutions being settled in Africa to solve the investment disputes, or having African arbitration centers to solve the dispute. And this was the compromise. Now that was the compromise to make some states accepting a reference to investment arbitration in the Pan-African Investment Code. So this is a real concern in the everyday life of many African countries, that they say it loud or not. It's a real concern.
Thank you. Any other?
Yes.
Yes, Ambassador Namira.
Just to comment quickly on both questions, the previous one and this one. The main issue that we are always faced with is the issue of the capacity that we have. Yes, we have African lawyers, and some of them are very competent, but they are not as wide in their expertise as much as in the Northern Hemisphere. Because when we go to investment arbitration, it's not only about the general rules of investments, it's about the specific rules. Some now are, for example, in investment only for construction. So they know all the rules about this. So this kind of expertise in every specific field, pharmaceuticals versus construction, this we still need a lot, which is also, it's not about the political will of our states to pick African arbitrators and lawyers alone, but also that's why we are focused so much on this capacity building issue. When it comes to the issue of the African states choosing the arbitrators, whether they are Africans or not, is affected by this capacity issue, and at the same time of knowing we have those qualified Africans. This is the attempt from our side to showcase the Africans who are competent to work in such cases. When it comes to the issue of justice, it's more of the BITs, more than the arbitrators and the lawyers. And this is something we have to pinpoint. This is where we are currently trying to tackle and to support studies on the matter, as Professor Makane mentioned, the issue of South Africa and how they dealt with BITs. But for example, I'm coming from a country with the biggest number of cases before exit when it comes to investment arbitration. So I know how far we suffered. It's all because of the BITs and drafting the BITs. And this is one of the things, apart from the attempt to see if we can suspend them, how can we deal with the current BITs. But for the future, what we are trying to do is now assist the qualified, competent lawyers within the governments to know the flaws in these BITs, so they will avoid it in the future in any agreements relating to investment. Thank you so much.
Thank you very much. Now we've got a number of other questions, so I'm going to try to get through as many of them as possible, and if the answers could reflect the need for brevity, I'd be very grateful. So Chandni Gopal has got a question.
Hi there, this comes from South Africa, and I really can confirm what Makane has been saying about South Africa's rationale for really trying to resolve international disputes domestically first. But really my question was around whether Tafadzwa particularly, in your experience, have you seen unconscious bias in respect of African countries coming out in arbitrations, arbitral tribunals particularly?
Thank you, Chandi. The example of South Africa is really impressive, and it doesn't solve the inclusion issue in the sense that South Africa decided that it wasn't going to participate in this arbitration as it's taking place internationally because of various reasons, and decided to step out of it. And I think that really is important in addressing many of the issues that Makane raised in terms of the issues around investor-state arbitration. I think where there have been unfair decisions, it really hasn't been a result, in my view, I haven't seen it being a result of the race or the ethnicity of the arbitrators who are on the panel. I think that there are certain concerns with investor-state dispute settlement, and whoever you have on your panel, if the treaty is being interpreted in ways systematically that are unhelpful to a state, that may be the case whether or not you have an African arbitrator or somebody else. And I mention that because it's not a panacea to appoint an African arbitrator. One of the major cases that people talk about when they talk about international arbitration and the problems and how it can lead to states having to pay billions of dollars had an African arbitrator on it. The African party appointed an African arbitrator But the problem could have been potentially that it was difficult to convince this third person, who is finally the person who has all the power, the president, to decide alongside with them. And the problems, again, go back to what is in the treaty, how has they been interpreted, all of the problems that are not going to be solved entirely by who you picked. And I think that's why the work that that the African Union is doing is so important with investor-state dispute reform, and making sure that African voices are heard, because they will not be solved if you just replace the arbitrator with an African one. If the rest of the panel are non-African arbitrators, and if you have the law that we have currently. Thank you.
Thank you, Taffy. So now Jarek has got a good question here, which perhaps all the panelists would like to answer, but we'll see who gets in first. Jarek, your question.
Thank you. Yeah, it's a rather legalistic question. How we define an African arbitrator? I come from Belarus, which is a former Soviet Union country, and we have a similar problem. There are many cases against former Soviet Union states, but almost none of them is resolved by arbitrators coming from that particular region. They're usually resolved by British, American, Swiss arbitrators, but not by arbitrators from the region. And so my question is, how do you actually define arbitrator? By their citizenship, their place of birth, their first law degree, the color of their skin? And I know it's a tricky question, but perhaps there are some practical solutions to it. Thank you.
Well, now, Ambassador Namira, would you like to have a go at that?
Well, de facto, it's a very difficult question, but we consider all those of African descent, like the African diaspora, are Africans. Tafadzwa, for example, we consider an African. She's living in DC. Professor Makane doesn't carry any other nationality but an African nationality, so he's African. He lives in Switzerland, but he's an African. So more or less, this is where we are. Like we try, it depends on, unless it's getting into conflict of interest issues, we try to take the African diaspora and African citizens as Africans when we are trying to widen our pool of expertise. I hope that helps a bit. It's not a real legal definition because we don't have a legal definition, except if we say by citizenship, like we carry passports of our member states. If you want to be appointed by the African Union, you have to carry a passport of an African state, even if you have a double nationality. This is another issue. But for the pool of expertise, when it comes to lawyers, as long as like they were Africans and they traveled abroad, they are fine. We still take them on board as part of our pool of expertise. Thank you.
Well, now
Barack Obama wouldn't be an African because it's been a while since he moved, right? But let's say a white South African living in London would qualify.
Yeah, but
that's the last intervention.
Professor John Dugard is still African, 100%.
Well, that's a very interesting answer, Namira. I don't know whether I would count as of African descent. It is a long time ago, but my ancestors spent 400 years in Egypt a long time ago.
You occupied us. You're not allowed.
Well, we've got, it's 10 past, what is our, oh no, we've got time, we've got time. Does anyone else want to go, Makane or Taffy, on that question, briefly?
Well, it just makes me smile because it reminds me of an episode with our friend and colleague, Wan Kidan, who was based in the US, was American, but he's also Ethiopian. But in Ethiopia, if you have another nationality, you lose your nationality. And when we started to discuss this all, what is the definition of African arbitrator? Of course, one was not very happy with the legalistic definition that Ambassador Namira gave, because he feels African, he's African, it's just that he comes from a country that does not accept the double nationality. So I would be in favor of flexibility, but Jarek, I think your question is very important. We need also to sit down and think about what we mean. But one thing I want to say, Sir Bernard, is that the idea of those lists I was mentioning is not also to exclude arbitrators from other regions or from other countries. No? The idea is that we believe in diversity in arbitration. Nobody, at least the people, the serious people I know in Africa, nobody is saying, you know, when you have an investment case against an African country, all the 3 arbitrators need to be African. We believe in balance, diversity in the process.
Thank you very much indeed. Well, let's go on to our next question, which is from Sarah Al-Shahrani.
Thank you very much. Thank you. I'm a Saudi PhD researcher at the University of Leeds. My question is regarding the investment mediation. There are many studies who has suggested that mediation should work better than arbitration for various reasons, that keeping the relationship between 2 parties safe, as well as saving for money as well, time consuming, and eventually maybe the dispute with lack of jurisdiction, or as I'm coming from the Gulf region, there are many disputes who's been settled even for arbitration. So why you didn't go to the mediation straight away? I would like to hear from Professor Makane, if possible, about the African views regarding the mediation.
Makane.
Yes, thank you very much, Sarah. You know, African countries are actually very open to the idea of mediation or conciliation when it comes to the settlement of investment disputes. If my memory is good, 70% of the conciliation cases in the ICSID system were actually, you know, cases involving African countries. So there is some good perception of using mediation or conciliation. And actually during the negotiations of the Pan-African Investment Code, there was a lot of insistence on mediation. And that's why if you look at the provision that is in the current draft of the Pan-African Investment Code, you will see that before contemplating arbitration, there is a provision that is requiring the disputing parties to use mediation during a certain period of time before they can contemplate recourse to investor-state arbitration. So these are ideas that are on the table. You have countries that are saying, let's use some, you know, alternative means of dispute resolution. Arbitration is too confrontational, you know, and so on. So it is there. But once again, I am more for the balanced perspective. I think it's good to contemplate the use of mediation or conciliation even as a preliminary step, but we should not also exclude totally the possibility of arbitration because, you know, access to justice has become so fundamental today to guarantee a predictable investment climate.
Thank you. And now Duncan Bagshaw has a question. Are you there, Duncan?
Good afternoon, Sir Bernard. I hope you can hear me.
Yes, you could make yourself a bit louder, perhaps, if you can.
I'll do my best. My question is relating to the role of arbitrators. It's sometimes said that what happens behind the curtain in the deliberations amongst the tribunal is one of the most significant parts of an arbitrator's role, and it is occasionally used as a reason why there is a reluctance to appoint African arbitrators, because for reasons of lack of experience or other reasons, they don't hold the same credibility or sway in those deliberations as more mainstream, well-known Western arbitrators. And I just wanted to ask the panel to give any experience that they have of that, whether it's being used as an excuse or whether it's a real phenomenon that they have come across in life. Thank you very much.
Taffy, would you like to have a go at that?
Yes, thank you, Sir Bernard, and thank you, Duncan, for the question. I think it is a real concern of states, and that's why I've emphasized this point, because I think I think parties just don't know. They don't know what the other arbitrators are thinking, and this is an issue that concerns both ethnic diversity and also gender diversity. So you will see, although gender diversity figures have become much better, that I think right now maybe ICSID reports about 10% of cases have got women arbitrators, but claimants, I think claimants in ICSID cases pick a woman arbitrator maybe 2% of the time of all, and they're bringing the cases. So and those are the same figures that I said of African states. And I think there's still this concern, given that this is such an important decision. There is, you can't be certain how the other arbitrators are thinking about what their perceptions are about women, what their perceptions are about African people, or just wanting somebody who's the most foremost in their field, and because of the way the field has developed, that person happens to be a European person. You just don't know, and I think that concern and knowing what the outcome could be, how high the stakes are, is exactly why states are cautious at this point about appointing Africans.
Thank you very much, Tafi. Any other? Ambassador Namira.
Yes, actually I wanted to comment on the previous question as well, specifically on conciliation, if you allow me, and then I will pick up to complete something that Tafi was saying. The important issue with the conciliation and mediation in some states, including mine, the challenges of the conciliation and not having to resort to courts to settle, because this is one of the major issues in the internal laws. In our internal system, for example, to effectuate payment has to come after a judgment. So if you have a judgment from the arbitration or a judgment from a court, then the government is able to effectuate the payment. So that was a challenge in the internal legal system. Because of what happened in the last 10 years in Egypt, they had to change the law to allow this conciliation to take place. And once there is a settlement amicably away from the arbitration, it allows the government to pay. So that is a challenge that countries need to tackle, like we have tackled it, in order to be able to have more of the mediation and conciliation rather than wait for an arbitral award. When it comes to the issue of the lawyers, the last question, there are two folds. One of them is the perception of qualification. What Tafi was speaking about regarding the women lawyers, exactly like or arbitrators, it's the same like the Africans. It's the perception that women or African lawyers have less qualifications than the others. So this is one of the things that we are trying to work on to change that perception in order to make sure that more qualified women lawyers and African lawyers are there as a showcase to our countries and our governments to pick from. One issue that I have noticed in the last couple of years while interacting with many of the international law firms themselves, where they have African lawyers, once it's African cases, they don't show the African lawyers. It's always others. So this is something also that is affecting African governmental officials to see the African expertise. Like if I have a team going to one of these big firms, they are all coming from the north. So the image for me as a governmental official, that basically these are the qualified ones. And these are the ones that I'm trusting because of the big name of the law firm that I already knocked on the door to hire. So hiding the African lawyers in these firms from African countries as well, one of the things that is somehow, it's one of the drawbacks and a challenge. Thank you.
Thank you very much indeed. Well, I think we've run out of time, but in the meantime, I see that dawn has reached you in Washington, Tafi. At any rate, I want to end by thanking my panelists very much, Ambassador Namira, Professor Makane, and Tafi. Thank you very, very much for your contributions. I have enjoyed listening to you and to your answers to the questions. Very, very much indeed, as I'm sure everyone present today has. I thank our question makers. I want to finish by saying that I'm deeply honored by being asked to moderate this session. I've been asking myself whether my presence here is a mark of non-inclusiveness or a demonstration of inclusiveness. But at any rate, thank you all very, very much indeed. And over to you, Jarek.
Thank you very much, Sir Bernard, for your skillful moderation of this panel and the finishing on time. And we now have a 10 minutes stretch break before we move to panel 2, dealing with investment treaty challenges. Thank you very much, all the panelists, for joining us